Okay, so I have a couple questions. First of all, you explained how demographic changes have lengthened the terms of Supreme Court nominees. Is that a bad thing? Because part of the purpose of the lifetime appointment is to insulate them from swings in politics, is it not? So, I mean, there are people out there who are proposing that we should have term limits on Supreme Court justices and things like that. So, do you see that as a feature or a bug?
For the most part, I think that the wisdom of the framers in creating lifetime tenure is a good thing. And I am painfully aware of that, and I know the judges here in Texas are also aware of that because they have to face retention. And I am facing retention in Arizona this year, and an interest group is really, really upset about one of our decisions, and the best way they can punish us for that decision is by taking the two of us who are on the ballot out this year. And I think that's something, obviously, that doesn't happen at the U.S. Supreme Court. I think the worst thing that could happen is when a judge looks over his or her shoulder and to see who might be watching when you're trying to adhere to the rule of law. So I think even though it was never intended that a justice would necessarily serve for 40 years on the U.S. Supreme Court, I think that lifetime tenure is better than whatever alternative there might be.
Than elected judges?
Yes.
Okay, all right. Because as you say, we have elected judges here in Texas, but it does make them vulnerable to swings in political opinion.
Sure,
sort of
and
thing,
of
right?
course, raising money also is not something that it's fun for judges to do, but also it creates potential for conflict.
Sure.
One of the questions asked about your background. Did you decide as a young kid that you wanted to go into law? What in your background took you to the place where you are?
So I appreciate that question. I'll try to make it very short. I had not planned to be a lawyer at all. I didn't know any lawyers, and the ones I saw on TV, it seemed like an incredibly boring profession. And so I had planned to be a teacher and to go into politics. And it was my student teaching experience at an inner city high school in New Jersey that really opened my eyes to how many kids do not have a high quality educational opportunity available to them. And I decided that systemic change rather than a student at a time kind of change was something that I would prefer to advocate. And then I interned on Capitol Hill for a fresh-faced freshman senator named Orrin Hatch. Senator Hatch is leaving this year after, what is it, maybe 40 years, right? But I found that DC was all about shades of gray, and I am much more of a black or white person. And I took a course in constitutional law, and that's where it all came together for me. It was an epiphany. Seeing a case like Brown versus Board of Education and seeing systemic change consistent with the Constitution literally being able to happen. And I decided I wanted to be a constitutional lawyer, and fortunately, no one told me that almost no one gets to be a constitutional lawyer. So in that blissful ignorance, I went to law school. I managed to become a constitutional lawyer, and I've just enjoyed my career so far more than anyone should be justified in being able to do.
Cool. You mentioned the fact that the courts have become more powerful and that Congress is somewhat reticent to do its job. And I think that there's probably broad agreement that Congress is reticent to do its job for various reasons. But is the court, in general, are courts too powerful? I mean, it was striking early in the Trump administration when Trump was trying to reverse President Obama's DACA decision. And, you know, a federal judge halfway across the country issues an injunction that ties the hands of the executive, which struck me as something the founders might be surprised at, that a judge, that among three co-equal branches of government, one branch could tie the hands of the other.
So the issue of national injunctions issued by federal district courts is one that is moving quickly to the US Supreme Court, and as a result of that, I can't comment on that specific issue. But I see even on my own court, on the one hand, courts routinely defer to the other branches of government when it comes to the constitutionality of laws, and I find that improper. It's not up to the other two branches to decide what the limits of their own authority are. That is the power, that is the province of the judiciary. So we don't do that. But if a law comes to us and it's unclear, we have no problem rewriting that law. And I consider that to be totally inappropriate. It's been ironic to me that most of my dissenting and concurring opinions, or more than any other topic, have been about, we don't have the power to do this. Scalia once said, or more than once said, if Congress passes a law that is garbage and they send it to us, we are constitutionally obligated to send garbage right back, because it's their province to write the law. It is not ours to correct what they did. And he said, garbage in, garbage out. And I think, boy, isn't that a slogan to live by as a judge, you know? But so basically, it's frustrating to me that courts don't do nearly as much of what they were intended to do, and way too much of what they were never intended to do. And as a result, they have become part of the problem.
What's the most important characteristic for a judge or justice to have?
I think really it is to interpret the law in as neutral a fashion as you possibly can. And I was even wondering, and there are a lot of people wondering whether I would be able to do that. And I even wondered whether I was able to do that. But I found out, I discovered very early on that that has been the least challenging part of my job, because a good lawyer is able to size up a case early on in a very objective fashion. If you're not good at that, you end up losing a lot of cases. And then once you've made that assessment, you go on to advocate. And what a judge is supposed to do is to neutrally size up a case and then stop the process. Mm-hmm. And I've found it's exhilarating to find that the law takes you to a destination that your own policy views may not take you. Justice Gorsuch, in his confirmation hearing, said any judge who agrees with all of the outcomes of all of his rulings is probably not a very good judge. And my wife heard him say that, and she said, "He sounds just like you."
So you've made some decisions that you don't like, but you had to make it because that's where the law went.
That's absolutely right. And I know I don't like them because the Goldwater Institute was on the other side of them, and boy, were they probably really irritated.
I have several questions here about, in the wake of the Kavanaugh confirmation, there's been some chatter, particularly on the Democrat side, about packing the Supreme Court, about increasing the number of judges and that sort of a thing. Is there anything sacred about having 9 judges on the Supreme Court? And can Congress change the number of justices on the Supreme Court?
So I was so tickled to learn during lunch that Congressman Sumners, who was the namesake of the foundation that sponsored, hosted this event, was a major part of the opposition to FDR's famous court packing plan. And I think that Congress does have the power to increase the size of the court. And that's a debate that the American people really, really need to have. I think that there are very strong reasons. There's nothing sacred about the number 9, but on the other hand, there is everything sacred about the integrity of the court. And so when and if that conversation comes, I hope that people will apply neutral principles to say, hey, is this is this something that we want to do? Do we want to alter the size of the court so that this president, whoever that president is, will be able to dictate the outcome? And I think, I would be somewhat surprised if we didn't see the very same reaction that we saw in the 1940s with FDR.
So I have several questions along the lines of, do you envision the new court rolling back the power of the federal government and limiting its power in some ways?
I certainly see that in regard to the administrative state. And this is, by the way, an issue that where we may see liberal justices and conservative justices joining together in somewhat of an odd couple coalition, because the power of the administrative state cuts in every, in every direction. And one thing that will be really interesting to see, and I know that people will be watching Justice Kavanaugh very closely on this, another area of the growth of the executive is not just administrative agencies, but the use of executive orders. When we see Congress coming to a complete impasse on so many issues, presidents, and this goes back a long ways, but it accelerates with every administration, including this one. You just issue an executive order, and so it will be very interesting to see. Certainly a Trump executive order will come before this court, and it will be very interesting to see whether Justice Kavanaugh will, buck the president who appointed him.
In my introduction of you, I mentioned that you have a particular, I guess the right word would be that this is sort of one of your hobby horses, is that state constitutions are a neglected tool for individual liberty. And I would like to give you an opportunity just to talk for a couple of minutes about that. I mean, I don't know what's in the Texas Constitution, I don't know if it's good or bad. I have no idea. And I think that's probably very typical, that people really, they don't give serious consideration to their state constitutions.
Well, you go to law school, you take a course in constitutional law, and it is as if there is only one constitution in the country. It is the federal Constitution. In reality, the state constitutions were intended to be our primary protection of our rights and of the limitations of the power of government. I'm happy to say that my number one example of the use of a state constitution comes from right here in Texas. One of the things about state constitutions is that they have provisions in them that are not in the federal Constitution, and fewer barriers to access to the courts than exist in the national Constitution. And one of the areas, and the other thing is, state courts are free to interpret their own constitutions more broadly to provide greater freedom than the national Constitution, but not less. So it's only a ratchet in one direction. So one of the areas of great passion to me as a litigator was protecting freedom of enterprise against occupational licensing laws and other types of government regulations. And under the national Constitution, it's a super uphill battle to win those cases, whether on behalf of someone fighting taxicab monopolies or African hairstylists or whatever. But right here in Texas, the Texas Supreme Court struck down an occupational licensing law that forbade eyebrow threaders from plying their trade. To this day, even though my daughter has tried her best, I still have no idea what the heck eyebrow threading is. I do have a tattoo from having represented a tattoo studio. If I ever represent an eyebrow threader, I'm not sure I'm going to be doing that. But this was an incredible decision, and it was under the Texas state constitution. And my dear friend, Don Willett, who served as a Supreme Court justice and is now on the Fifth Circuit, wrote a concurring opinion that extolled the virtues. The case is called, by the way, Patel, P-A-T-E-L, versus some Texas agency. But it extols the independent vitality of the Texas Constitution as protecting individual rights, and in this case, the right to thread people's eyebrows free from excessive intervention by the state.
So if you're a Federalist, did Don Willett get a promotion or a demotion?
You know, this is the thing. I was actually approached about serving on the Ninth Circuit. The Ninth Circuit is kind of a story unto itself.
They weren't going to nominate you. You were just approached.
Yeah, that's right. I was stalking.
What your name?
But I would consider that, in a sense, a demotion, in part because the state Supreme Courts are courts of where we get to choose, for the most part, which cases we decide, and that means that we get to choose the most consequential cases. It's what's called a discretionary review court. Federal circuit courts, you get whatever comes, and it could be boring, it could be consequential, or whatever. And so I would not make that trade, but I know that Don is really, really happy.
So that leads me to the next question. Are there ever any clashes between a state Supreme Court and either the federal courts or the Supreme Court?
A lot, and I wrote one concurring opinion where we had to do something. The U.S. Supreme Court ruled that lifetime sentences for juvenile murderers, you had to go back and basically relitigate every single one of them to see whether the person at the time of the crime was permanently incorrigible, could not be redeemed, which is really like using a crystal ball. And I think that it was Justice Kennedy who said, and in the vast majority of those cases, we will find that the juvenile was not irremediable. And we have no choice but to implement that, but we can say what we think about that. And in that case, I wrote a concurring opinion with my colleague saying that it was bad enough for the court to render that decision in the first place, but it was even worse to forecast what the result would be in individual cases going forward. We have no idea. It's a case, our entire criminal justice system is based on a case-by-case determination. And I thought that was outrageous, and so I said so. So yes, there are some clashes. Are there clashes between the Arizona Supreme Court and the Ninth Circuit? You bet. It happens all the darn time. And all I can say is that the Ninth Circuit often does not have the final word because more of its decisions get reviewed by the U.S. Supreme Court than any other circuit.
So I have a question here that you could write a book about. What do we mean when we say liberal justices or conservative justices? But as a glide path to that question, for those who don't know, the Ninth Circuit is regarded as a highly liberal court, and thus viewed. Many of us look askance at decisions that come out of the Ninth Circuit, but
which is frequently overturned.
That's
Yes.
right. But what do we mean in general when we talk about a liberal judge versus a conservative judge?
Well, and this is a super oversimplification, and generally speaking, there are at least two. There are actually many. Anyone who's ever been to a Federalist Society meeting talking about constitutional philosophy knows what I mean. But there are many schools of constitutional thought, and generally speaking, conservative justices adhere to a philosophy of textualism or originalism, that our goal in interpreting the Constitution is to interpret the words of the Constitution as they were meant to be interpreted at the time that they were created, applied to how our society has evolved. Generally speaking, liberal judges tend to view the Constitution as a living document that changes as the times change. These are two very worthy constitutional doctrines. That is the reason I say it's an oversimplification. I consider myself a textualist, and there are a lot of liberal judges, including the most liberal judge on my court and the most liberal judge on our state court of appeals, who are textualists. And they sometimes, but not always, come out with different views. But we also agree a fair amount because that textualist philosophy leads you to the same place. But that is an oversimplification, and yet on the most contentious issues facing society, they tend to produce different outcomes. And as a result, generally speaking, you can predict how the court will come out in a particular contentious case, like the rights of individuals not to pay union dues, or a case involving the use of race, or a case involving the constitutionality of the death penalty. It truly is an oversimplification. But there are two very different ways of viewing the Constitution, and generally liberals adhere to one and conservatives to another.
I think we have time for one more if you have a good one over there.
I'll raise this one.
Okay.
The federal government is in charge of immigration, as I understand it. If a state Supreme Court says we need to do something about this, and I'm bringing this up because it's a huge topic right now, especially with the migrants coming, can the state Supreme Court say we need to go ahead and act if the federal government isn't going? Do you have the authority to do that? How far can you go?
I will say this in a more generic way.
Because it could come up.
Exactly. Where the Constitution assigns a power to the federal government under the Supremacy Clause, that's the end of the story as far as where the power resides. However, the second stage of that inquiry is whether Congress has preempted state action or not. And that is a very, very difficult issue because it can expressly preempt state action by saying states can't do this, or it can impliedly preempt state action by regulating so extensively that it has occupied the field of law. If it has done neither of those things, then the state can regulate in an area that is assigned to the national government, so long as it doesn't violate the Constitution when it does so. So you can apply that framework and answer your question.
Okay, I want to invite IPI Chairman Marv Bramlett to come up and make some closing remarks. And in the meantime, would you all please join me in thanking Clint Bolick
Thank you for
being
having
with
me.
us.